help the respondent number 1 to respond.
My lord.
Is that all right? No, Mr.
Sir, yes, I can begin do that straight away.
So then we will allow his request, and we will try to incorporate whatever you say today. Naturally, you may want to add something later, but then he'll be hearing himself. But it will give the respondent number 1 time to absorb and respond to them also.
And if your lordship wants to facilitate him further, I can, and to save your lordship's time, instead of submitting that orally, by early tomorrow, give a list of propositions and provide it to the court staff, and those can be communicated to him. Whichever way your lordship pleases. I can articulate them now, or I can give them in writing by tomorrow morning.
तुम सब हम तो देख लेना
जी सर, मैं अभी
हम आगे ट्रांसमिट करते हैं.
Can you just since we've assembled, we don't want to waste this day. We may do both.
By law.
We may also then call upon you to write them down later. You may want to think, but so can we hear you,
my lord,
on the fundamental questions?
My lord, let me begin straight away.
Don't go into the facts, just the legal proposition.
Just the legal proposition.
Makhdoom Sahab,
sir, my lord.
Speaking for myself, there's one appeal by the federal government,
my lord,
and the others are by private person.
My lord.
Section 5 of the Act जो है, Practice and Procedure, my understanding is that only an aggrieved person can file an appeal. So how is the Federation aggrieved?
My lord, because a statute of the Federation was struck down.
Sorry, आपका आवाज.
My lord, 2 reasons. One, the Federation was the respondent, and it was a statute, federal statute, which was struck down. So if the Federation is not a respondent, then in that event, in a situation like this, where NAB didn't come forward as an appellant, then virtually every decision made by the court would be final and there would be no right of appeal. And your lordship knows that even if we move away from 184.3, wherever statutes are struck down under 199 by the High Court, constitution petitions are filed under Article 185 of the Constitution and have been heard by this honorable court, and the Federation has never been non-suited on that ground.
Here we have to interpret Section 5 of the Practice and Procedure Act.
Yes, ma'am.
Subsection 2 was in fact struck down by this court.
Yes.
But when you read subsection 1 and subsection 2,
yes, my lord,
it is an aggrieved person. And this court consistently has interpreted the expression aggrieved person as a person who has suffered a loss. A department or the government has not been treated as an aggrieved person for the purposes of an appeal.
If your lordship may see Section 5.
I think there are 2 slight variations to the proposition. The first variation is any party to litigation, if a case is decided against him, will be presumed to be an aggrieved person. There may be third parties who may come forward and say, I am aggrieved by this person. In my opinion, those persons will have to show how are you aggrieved, as opposed to every petition that is filed, I'm aggrieved by this judgment. We don't delve into the question, how are you aggrieved by this judgment, if he's a party. If he's not a party, then HM principle applies or not. Then we ask him how you aggrieve. You are a party, it is taken that you are an aggrieved person. Otherwise, that party would not have been arrayed as a party to begin with.
My lord,
so why did the petitioner make him a party?
On same principle, we are allowing the respondent to appear and to argue the matter.
And may I also...
One thing more, Mr. Who proposed these amendments to the Parliament?
My lord, I'll come to that in a moment. May I just draw your lordship's attention to Section 5 itself, and your lordship will see that the word aggrieved person is missing from there.
But the fact is, again, this debate will become academic since you are one of the petitioners yourself. There are the private parties as petitioners themselves.
Yes, my lord.
So can we have your propositions?
My lord, yes.
Ji.
My lord, my first proposition before your lordship is that during the pendency of this petition, the Practice and Procedure Act of this honorable court was enacted. And with that inaction, we made...
Even if you now you come back to the Practice and Procedure Act, please read Section 5.
My lord, yes.
पढ़ दें उसको.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And that's what I was submitting.
And please read subsection 2 as well.
Subsection 2, which has now been...
it has not been upheld by majority.
Yes, the right of appeal under subsection 1 shall, and I emphasize the word, also be available to an aggrieved person against whom an order has been made under clause 3 of Article 184 of the Constitution prior to the commencement of this.
So it's only
Not part of this statute.
It adds the aggrieved person, you say? It adds the aggrieved person.
It broadens the definition.
Yes, my lord, but the word also, and your lordship will know that right from Fazaldeen's case in 1969, even the definition of an aggrieved person, which now is there under Article 199 of the Constitution, this honorable court in questions relating to fundamental rights has taken a relaxed view of that. And one of the principal distinctions being pointed out between 199 and 184 3 is that under 199 you have many of the other trappings, as they are called, where the court can regulate the jurisdiction. The word aggrieved person is missing from Article 184.3, which is there under Article 199. My lord,
इसमें मखदूम साहब, this is a statutory appeal.
My lord, yes.
Statutory appeal में,
Yes, sir.
in case of Customs Act, there are 3 judgments of this court, 3-member benches, where the Custom Act only then had provided a right of appeal either to the collector or an aggrieved person.
Yes, my
The
lord.
Director Intelligence had filed an appeal, and this court held, and it was the argument of director that I'm an aggrieved person. This court held, you may have been disappointed with the judgment or the order, but you cannot be an aggrieved person because no personal loss has been suffered. That is how this court, in case of statutory appeals, has interpreted an aggrieved person.
My lord, there's a fundamental distinction. The fundamental distinction is between a statutory appeal arising out of a statute and a statutory appeal arising out of a constitutional remedy against which previously there was no appeal at all. If this interpretation is accepted, and if under Article 184.3, this honorable court strikes down any statute, that would mean that there would be no right of appeal at all to the Federation. The other distinction is that over there, it was the officer concerned who had come up in appeal. Over here, it is not the current incumbent Prime Minister of the country or a particular official or a Director General of NAB in his personal capacity who has come before your lordship, CPC. The person who has come before your lordship is the Federation. If the Federation does not have a right to defend its statute, then who else would? And particularly in a case, this was a case where the petitioner had come to this honorable court. There was no real controversy before this honorable court. The petitioner had not been affected by the operation of any of the provisions of the NAB law. The petitioner had not suffered any grievance against any of the provisions of the NAB law. He had raised, and that's the submission made, which didn't find acceptance by the majority. The petitioner had raised an issue, and the issue raised by was that this violates the fundamental rights. He never maintained that it violated his fundamental rights. He made the Federation a party. The Federation of the
Can we go with the
I've only-
propositions? Otherwise, we
My
will
lord,
not make any
I've
headway.
only raised a question. आप इसको बाद में देख
absolutely, my lord. Everything which your lordship says merits and is worthy of immense consideration.
But
And I
our
will,
propositions, Zakir, because
my lord,
the
yes.
respondent number one is not hearing this.
my lord,
He may want to hear this.
My lord.
If you formulate the propositions,
my lord, I will.
then we can send the propositions and then
My lord, the very first proposition is that during the pendency of the petition, the Practice and Procedure Act was enacted and an application was moved before the Honorable Division Bench that this matter should now be placed before the Committee for Constitution.
please refer to that application.
My lord, I will. My lord, may I just give you lordship the date? This statute came about on 21st of April 2023. The Federation filed CMA 7066 of 2023.
70.
66 of 2023. This is dated 28th of August 2023.
Where will we find it? Which page?
My lord, and your lordship will find it at page 402, part 3 of my intra-court appeal.
Four zero.
402, my lord, part 3 of my intra-court appeal.
Where's the order on this one?
My lord, the order was passed by this honorable court on,
First, let's read the prayer.
yes, my lord.
Then
427 onwards, but let me just point out, your lordship will see on page 402, I produced a note. If your lordship will see page 404, I make a specific reference to SCPA 2023. Its provisions are reproduced on page 404. Case law is cited in support in 406 and 407 and 408. I make other submissions as well, and I'll come to that later. And then your lordship will see the prayer. It is most humbly submitted that the
Page 413.
page 413, that the proceedings in the present petition may kindly be adjourned till after final decision in Constitution petitions number 6 to 8 of 2023 regarding validity of the SCPA 2023, or alternatively a full court be constituted to hear this.